we've seen more denials than ever coming out of Guardian, and mostly done with just paper reviews and basically saying, let's deny it, let's see if they come back to us. And then on appeal, they're being tougher than they used to be on these particular claims. But you have to be aware, if you're someone who has a Guardian disability policy, that Guardian, in my opinion now, is kind of looking for the lowest common denominator to deny a claim. If they can find any little thing that's inconsistent or something that they think they can lean on, they're going to rely on that. Hi, I'm Greg Dell, joined by attorney Stephen Jessup, and we're going to talk about tips to fight a Guardian long-term disability insurance denial. Now, Stephen, you've handled hundreds, if not, and reviewed thousands of probably Guardian disability denials. Guardian's one of the largest disability insurance companies in the country. And in this video, I want to discuss some of the things that people should initially be thinking about if their claim has been denied, and how we immediately go about putting together a plan of attack for a denial. Because really, once you get denied, the first essential thing that someone does not want to do is just write back and say, I'm appealing the denial, you got it wrong, please show it to someone else. This is not like calling for a manager in a restaurant because you didn't like your dish or something went bad and the manager just comes over. It's extremely, extremely important to handle your denial the right way and to put together what we consider to be an extensive appeal package that would then get reviewed. So what's the first thing that when you're looking at a denial that you would want to see?
Well, if someone calls first, the denial letter, it's going to give the basis, most of that even policy language. You know, it's always good to have the policy, but the denial letter, we usually set that forth. And then for us, I think we have kind of themes that we see in denials. So understanding the condition, the type of work that the person's doing, and then the patterns by which the insurance company is denying the claim. You know, we can get a lot of information off just the denial letter alone. But if we're hired, the first thing we do is get a complete copy of the claim file. And going back to what you said, one of the first things, don't just write a quick one. I would say second, don't sit on it. Act quickly, because the further away you get from the denial, the more argument Guardian has that any information you develop isn't time contemporaneous to the denial. So get moving on it very, very quickly.
Let me follow that up, because a lot of people do call us, unfortunately, like, hey, I got denied 2 months ago. And that's okay. We can help them. But here's the advantage of why you should contact a lawyer right away or get your claim file going, is because when you get that denial letter, it immediately says you have the right to request all of your records. And I think it says administrative record or a copy of your claim file. And it takes them 2 to 4 weeks they have 30 days to produce it, basically. And usually they'll take 3 to 4 weeks to get you that claim file. And then you get it, and it could be anywhere from, I don't know, it depends how, if you just applied, how much information you sent them, or if you've been on claim for years, it can be hundreds of pages to thousands of pages. I mean, I just did a case with a 14,000 page claim file. So you need to get that claim file right away. So leading off of what you just said about, reading the denial letter and don't delay, one of the things you don't want to delay is getting the claim file. Now, once we're retained, that's the first thing we do. We ask for the claim file, and we also ask for other specific information that could be conflicts of interest that they may have. But that's not something that someone's not represented is going to know how to do. So let's talk next about the claim file and why that is what I call the heart and soul of basically the entire, appeal, and what really has to be dove into in order to have any chance to win your denial.
Yeah, the claim file is everything, right? It's everything you submit or they've created. They don't hold things back. Their internal communications, reports, vocational reviews, all of it. So it is everything you need to know about what you need to attack. There's nothing that's left up to mystery. So, when we get a claim file, I personally, the way I like to break them down is into categories. Again, pulling out any medical reviews, any vocational reviews, because those are going to probably be the most important to attack. And as you know, a lot of times it's a lot of duplicated information over and over and over again. So it's also sorting through what's new, what's old, and what's repeat. But you have the entire basis of their rationale. So now you know what points you need to argue against. So some people who wait or don't get it in time, you're just kind of setting yourself up for a little bit of failure, because now you're behind the curve on it. So the claim file is going to be everything you need to know to what you need to do to perfect your case, essentially.
And also, when I get into the claim file, I'm also looking for what's known as SOAP notes, which is the internal notes and communications that were going on from the people who had reviewed the file. And I'm really, really digging into the medical reviews that the insurance company did, because at the end of the day, the insurance company put the claimant in this position because they believe their current doctors over the opinions of the treating doctors, right? So my frame of mind always when looking at this is, what additional information can I possibly obtain that is going to change the opinion of the insurance company? Now, one thing that's very significant that people should know is that when you do finally submit this appeal, it's not going back to any of the same people that initially made that denial. So it's not like, hey, Dr. Johnson reviewed this and said that there's no support or no objective evidence or whatever. It doesn't really matter so much that Dr. Johnson thought that, because they have to get someone new who's an appropriate medical specialist for whatever the disabling condition is to review the medical records. So yes, you're getting a clean slate, but the new people can still look back and refer to the medical reviews and the prior records and things that your doctors may have said in the past in order to evaluate their new opinions. So they're also going to document in terms of what are the weaknesses, what was missing. Now, what's super, super hard for claimants is a claimant, I always like to put myself in the shoes of a claimant, right? Claimant's point of view is usually like, I don't understand what's going on. I went to the doctor. I'm not going to work. I'm taking a substantial loss of income from not being at work. I did everything my doctor told me to do. I told the doctor what's going on with me. How do they have another doctor who's now telling me, maybe I don't even have this diagnosis, but even more so, yeah, we don't challenge your diagnosis, but we think that you are able to go back, not just activities of daily living, but go back to your work. So how is a claimant supposed to say, hey, insurance company doctor, you never saw me. You don't know me from the hole in the wall. You don't know anything about me. My doctors did see me multiple times, and now you just looked at my records and said, no, it's not enough. So how is a claimant supposed to know what to get?
Yeah, that's the big one. And we're asked that all the time. And I kind of try to tell people, don't try to apply logic to an insurance company's decision, right? Because if you do, it's never going to make sense. You have to understand what the insurance company's motives are. In any of my initial conversations with some of the denial, I do start with what this looks like in litigation, because if you understand the law, you understand why they're doing what they're doing, right? So there's not a lot of logic to it. Can explain it, and it is a $1 million question with it. So they are left with a sense of, defeat, in what they do. But us having done it so much, we understand, if this is a physical condition that's impairing, okay, what type of what we call forensic medical, right? Not something your doctor would necessarily ever send you to, but they're objective medical testing that we would want to see, functional testing, work simulation exams. If there are cognitive issues, is a neuropsychological exam right, or some other type of cognitive issue. So it's creating, in large part, since most conditions are going to have an element of the symptoms are going to be subjective as you report them, pain, fatigue, to sadness, depression, whatever the case may be, building objective evidence to that. Because a lot of times what the insurance company is doing, like you said, is they're attacking your subjective complaints as not having enough evidence. So where do we draw the nexus between what the medical records are showing, what your job duties are, and how do we build the gap to show this is impacting this? And in a way to the insurance company that I don't potentially like to be very combative, because I don't want to put them on hey, we'll prove you wrong, a simple presentation of the facts to really show where the impairment lies. So it's helping educate the individual on what they need, what we need to do together to build it up, and then coordinating that with the doctors.
So we are talking about specifically about Guardian here, and more as we're doing this video in 2025, we've seen more denials than ever coming out of Guardian, and mostly done with just paper reviews and basically saying, let's deny it, let's see if they come back to us. And then on appeal, they're being tougher than they used to be on these particular claims. But you have to be aware, if you're someone who has a Guardian disability policy, that Guardian, in my opinion now, is kind of looking for the lowest common denominator to deny a claim. If they can find any little thing that's inconsistent or something that they think they can lean on, they're going to rely on that. Whereas in the past, if there was any doubt, they would have given the benefit of the doubt to the claimant. And that's not the story anymore with them. So what does that mean now for somebody who is a guardian claimant? To me, that means is you got to make sure your treating physician is documenting every single thing that's going on with you with a high level of detail in your records. That also means that if there's any kind of testing that can help support what's wrong with you, you have to go out and get that objective test. When reality meets what we call the forensic, they don't necessarily merge together, because a lot of doctors, first of all, it's expensive to go to the doctor. These tests are expensive. And now you're a claimant and you don't have money necessarily set aside to pay for these medical tests. So a claimant, for example, if it's a back issue and there's an x-ray and the x-ray is already showing degenerative changes there, the doctor doesn't necessarily have to send the claimant out for an MRI or a nerve conduction study test, because the doctor believes the claimant that, yeah, your fingers are numb and that's consistent with the neck pain you're having, and I see degenerative changes in your neck. I don't need an MRI or a CT scan that's going to cost you $1,000 to go get now to objectify what's going on. That's the doctor speaking. Now you go to the other side and speak to us, who knows what's going on the forensic side and knows how the adjusters or the doctors or the claims examiners are going to, what I say, play games with the claimant, or what they're going to look for from the claimant. They're going to be like, where's the MRI? Well, this is reality versus what the insurance company thinks, and it's not fair to the claimants. But you have to know, you have to have someone experienced helping you with your appeal to be able to know, look, it's not fair. And you told them that, right? Don't use logic. It's not a fair playing ground. There's nothing fair. And unfortunately, there's nothing you can do about it in terms of getting the government or the Department of Labor or something to do something, because this is the conduct of how insurance companies act. The way you get back at them is you focus on what you have to do, which is you have to get as much evidence as you can possible to support your claim. And you have to be thinking already that if I don't get past the insurance company, how is a judge going to look at this? And that's how we look at it. We try to convey that to the clients, but we're immediately thinking, not that we don't want to win the appeal, because we win more than 65% of these appeals, but we're already thinking, how's the judge going to look at this? What's the standard of review on this claim? What's the judge going to have to do to look at our evidence and look at what they have? What witnesses does the judge want to see? So there's a lot that goes into it, and often claimants call us and they start to say, hey, can you just tell me a few things that I could do on my appeal? And as much as we would love, to do that, and it's general to say, hey, get as much evidence as you can, every medical condition has its own nuances. Every definition of the disability policy has its own nuances. Every expert that insurance company has used has its own nuances as to who are we going to go out and get. Like you said earlier, I think, are we going to do a functional capacity exam? Are we going to do a neuropsych test? Are we going to say to the claimant, go out and get these objective tests? Or are we going to put in these published medical articles that support exactly what the claimant's complaining about? Are we going to go out and get statements from, former coworkers, family members? Are we going to do our own independent medical review? There's so many things that can be done on these claims that it's important for claimants to really speak to someone who does this every day, and then consider working with an advocate to do that, because it's already an uphill battle, because you're not going in on a level playing field, because usually these policies have a different standard of review where the judge has to defer to the insurance company. So I mentioned a lot of things, and we do these videos for people to know what lays ahead, because a lot of people do their appeals on their own, and then they call us and think, oh, I can only get a lawyer because obviously I have to go to court. But you want your lawyer beforehand.
And I've even heard people say, they told me I can't get a lawyer until it's time to go to court.
Right. And I'm not saying Guardian tells people that, but sometimes the claim people don't even know. They're like, oh no, don't worry, just do an appeal. Because sometimes the claim rep, you see, the claim reps at Guardian or any company, they send their files out for a review, and 99,999 out of 100,000, they're going to listen to the reviewing doctor. That means almost every single time. But the claims person may not agree with that doctor. So sometimes they're trying to they come from a good spot, and they're trying to say, just appeal, you'll get another look at it. I think that doctor was ridiculous, but I don't have any power to overrule or disagree with that doctor, which is sad. And that's sometimes why they say it. I don't think that's always their intention, but I try to look at the positive and everything. But yeah, they think, and they don't and the claims people, This I know for sure. They don't appreciate the magnitude of someone not submitting a strong appeal.
Not whatsoever.
Because they don't realize that when the lawyer gets involved in these kinds of ERISA governed claims, we can't put in any additional evidence. We're stuck with what they give us. What we see is what we get once the appeal is done. And that's really essential. So these are some, basic, but really a high level conversation about what it takes to fight these things and the importance of having a strong advocate. So if you're someone out there with a guardian claim, whether it's short-term or long-term disability, feel free to reach out to Stephen, myself, any of our lawyers. We always offer a free initial phone consultation. And no matter where you live in the country, we're available to assist you.